Your Lordships, welcome to the first international moot court competition of His Highness Government Law College, Ernakulam. If your Lordships are ready, with your permission, let us start the session.
Yes, I am. I hope Sony.
Yeah, am I audible?
Yes, ma'am, you're audible.
Yeah.
So if your Lordships are ready, maybe now let in the participants.
Yes, yes.
So welcome teams IMC 113 and IMC 109. If the teams are ready, team IMC 113 and IMC 109 may please convey your time apportionment. So team IMC 113, how would you like to divide your time?
Speaker 1 will be taking 20 minutes. Speaker 2 will be taking 23 minutes and 2 minutes for a button.
Okay. And what about team IMC 109? Hello? IMC 109, how would you all like to divide the time among yourselves? Am I audible? Just a second, judges. There seems to be some problem. Hello, am I audible? Yes. So IMC 109, how would you like to divide your time? Your audio is breaking. You all can just type it in the chat. That'll be okay. Hello. So regarding the time division, if you all are not able to talk, you can just drop it in the chat. Y'all have told 20 for speaker 1, 15 for speaker 2, and 5 for rebuttal, right? But y'all still have an extra 5 minutes. That is, the total is 45 minutes. So if y'all would like to add it somewhere, y'all can do that. Your audio is breaking.
Team 109, if you want to, enter from another device, please feel free to do that because your voice are breaking.
Yeah, I think that would be better because we'll have to. We cannot go forward like this because the audio is not at all clear. Your Lordships, we are sorry for the inconvenience. We are trying to connect and we'll get back to you as soon as possible.
Yes, let them do it because without which competition can't go ahead.
Yes, sir. It's still not clear.
Hello.
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 Yeah, so about the timings, y'all still have 5 minutes left. That is, y'all can add it somewhere because the total is 45 and your total comes to 40. So in case you all want to add it, then you can do that. Sorry, your voice is not at all audible.
The first speaker, 15 minutes the second, 5 minutes for the results.
You're not audible.
Five minutes. Okay.
25 minutes for speaker 1.
25 minutes for speaker, 15 minutes for the second, and 5 minutes for
Okay, so 25 minutes for speaker 1, 15 for speaker 2, and 5 for rebuttal.
yes, it's correct.
Okay.
Before that, 109, we are still not audible about what you're speaking. We are not able to hear. It's breaking. So I advise either you log in from different system, or you can log off from this and log in once again and see if it's connected properly. It's a moot court competition. Nothing would happen without you. We could be hearing you. Sure.
Your lordships, in that case, can we just start with the arguments of the petitioner? And by that time, they'll make some arrangement regarding the technical issues.
That is also fine, but make sure that they clear it before that in 45
Yes, your
minutes.
lordship.
Otherwise,
Yes, your lordship, sure. So if your lordships are ready, I would like to invite the first speaker for the petitioner to speak, that is team IMC 113. So speaker 1 from IMC 113, your time starts now.
Greetings to the bench. The council seeks permission to address your lordship and your ladyship collectively as a lordship.
Yes.
Much obliged, your lordship. The council seeks permission to commence the pleading.
yes.
Much obliged, your lordship. If it may please this honorable court, the council is appearing on the behalf of the petitioner in the matter of Octa Limited versus owners and parties interested in Moonlight. The council would be addressing the first and second issue and would be taking 20 minutes of the court's precious time, while the co-counsel would be addressing the third, fourth, and fifth issues and would be taking 23 minutes of the court's precious time. We most respectfully reserve 2 minutes for rebuttal. The council is appearing before this honorable court under the jurisdiction of Section 3 of the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. If your lordships are well versed with the facts of the case, the council would like to proceed with the argument.
So I want you to speak once again on the facts of the case. In fact, court officer, please post the time till they when they say the facts of the case. Don't count it in their timing. We'll start the timing once they start with the issues. Okay, just give them some time. I just want to hear the facts of the case.
Yes, your lordship.
Much obliged, your lordship. The claimant, Octa Limited, in the instant case, chartered respondent's vessel Moonlight for transporting cargo to the west coast of Indo. The vessel was docked at the Deen Dayal port within the jurisdiction of that port. The charter party agreement and clean fixture stipulated that the vessel should only travel between safe ports and not enter war zones. It also stated that the parties shall resolve all disputes through arbitration at Lloyd's London. During the voyage, the vessel encountered bad weather, due to which the vessel listed 35 degrees to the starboard side, and the master of the vessel ejected around 500 to 600 metric tons of methanol cargo. During the survey, the claimants, fearful of cargo loss, petitioned the court for an arrest of the vessel, which was eventually freed after the owner provided security. When the claimants requested the cargo to be released, the owners resisted, claiming they were obligated to pay the general average security for the general average previously stated by the ship owners. The claimants contended that the ship was unseaworthy. However, the insurer of the claimant provided security for the general average and the cargo was released. Thus, the present case. The facts in greater details would be dealt as the council proceeds with the issue. The council seeks permission to proceed with the first issue in hand.
Sure.
Much obliged, Your Lordship. First issue being the exercise of admiralty jurisdiction by the court is valid in view of the arbitration clause in the charter party. In this regard, the argument of the council would be twofold. Firstly, the charter party agreement cannot supersede the jurisdiction of the court. Secondly, that the arrest of the ship comes within the jurisdiction of the court, notwithstanding anything written in the charter party agreement. As the lordships are well aware that the dispute in the instant case relates to non-agreement of the charter party terms. Therefore, the petitioner has approached this High Court. It is humbly submitted that the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017 unifies marine claims, admiralty jurisdiction legislation, including judicial actions such as ship arrest. In the instant case, claimant is the charter of the vessel named Moonlight, a seagoing vessel flying the flag of Indo. The owners failed to fulfill their responsibility to perform their part of the agreement with regards to taking due care of the cargo by jettisoning 650 metric ton of methanol from the cargo and thus damaging the goods. According to Section 4F of the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, the High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any loss or damage to or in connection with any goods. Your Lordship's arbitral tribunal does not have the power to arrest a ship. In this case, the judgment will never be equitable. This question of law can't be decided, and it's paramount to our essential interest that question of arrest of vessel can be adjudicated before proceeding to arbitration. Therefore, arbitration can't take place in a different country. In the case of JS Ocean Liner LLC versus MB Code in Progress case, it is well established that the arrest of the vessel is a right in rem. Now, Your Lordship, if you could refer to page 129 of the compendium, paragraph 57. Are you with me, Your Lordships?
Yes.
Much obliged, Your Lordship. 129 of the compendium, paragraph 57.
Okay, proceed.
Much obliged, Your Lordship. Your Lordship, in the case of JS Ocean Liner LLC versus MB Code in Progress case, it was held that because the dispute between the party falls within the scope of an arbitration agreement entered into between them, does not ipso facto preclude one of them from bringing the action in the High Court and procure the arrest of the ship or otherwise proceed with the action. The civil court jurisdiction is not ousted even in a case where there is an arbitration agreement. In rem remedy available to a claimant is not defeated by the fact that the claimant may have agreed to refer the dispute to the arbitration. As a result, even though the parties have agreed to arbitrate in a foreign country, the Indian courts have the jurisdiction to detain the ship. Your Lordship, according to Section 5 of the Admiralty Jurisdictional Settlement of Maritime Claims Act 2017, it talks about the arrest of vessel in rem. According to this section, the High Court may order arrest of any vessel for purpose of providing security against a maritime claimant. Your Lordship, in the case of Altus Suber and others versus Seam Offshore Redry AS and others, the court held that the Act 2017 is silent in the case where the arbitration proceeding can also be filed, and thus no procedure is laid down under the Act 2017 regarding the arrest of the ship if the arbitration proceedings are already in progress or are yet to begin. So, Your Lordship, in this case, the court relied on the Golden Progress case that granted the power to the Admiralty courts to arrest a ship for security. With regards to this case, it can be concluded that by relying on common law principles laid out in various judicial pronouncements, the arrest of the ship as security is allowed and valid. Therefore, drawing an analogy from the cases, the arbitration clause in the charter party of the exercise of Admiralty jurisdiction by the court is valid. If your Lordships don't have any further questions, the Council would like to proceed with issue 2.
Council, the question that I would like to pose is, are you actually looking at the jurisdiction of this court to provide security towards the arbitration proceedings, or you are actually looking at to argue the matter on merits before this honorable court?
Your Lordship, can you please repeat your question?
No, are you actually contesting that the jurisdiction of this honorable court, when there is an arbitration clause in the charter party, the jurisdiction is limited to providing security, or your argument is that this court has the jurisdiction to entertain the matter on merits? Are you limiting it to security, or you want the court to, you are of the contention that the court has jurisdiction to go into the merits of the matter?
Your Lordship, the Council is contending for the arrest of the ship. As it is a right in rem, it cannot be proceeded in it can't be proceeded to an arbitration. As right in rem are non-arbitrable. The Council is contending for the arrest of the ship.
Only towards interim arrest.
Yes, Your Lordship, only for the interim release.
So after that, you propose to go under arbitration?
Indeed, Your Lordship, the disputes regarding general average shall be decided at Lloyd's London. Since
Not
it's already
only,
mentioned in the
not only general average, there are seaworthiness and other things to be decided. So yes.
Indeed, Your Lordship.
Okay. Interim, yes, you are right in that. Okay.
Also, there is a contract for arbitration. Then how can the court go for this case?
Indeed, Your Lordship. Your Lordship, right in arrest of the vessel is right in rem, and this was clearly held in the Golden Progress case. Since right in rem is non-arbitrable, it cannot be proceeded to for arbitration at London. Therefore, the Council has approached this. Much obliged, Your Lordship. If Your Lordships don't have any further questions, the Council would like to proceed with the second issue in hand. Much obliged, Your Lordships. Second issue being, the declaration of general average is legally unsustainable if the respondent's vessel is unseaworthy. In this regard, the argument will be threefold. Firstly, the rule of general average is applicable to the dispute in the instant case. Secondly, the general average can be declared in case actionable fault is attributable to the ship owner. And thirdly, upon analyzing rules and laws, it is clear that in the instant case, declaration of general average is not sustainable. Your Lordship's general average is a principle of maritime law that essentially establishes that all sea cargo stakeholders, including the owner, shipper, etc., evenly share any damage or losses that may occur as a result of voluntary sacrifice of part of the vessel or cargo to save the whole in an emergency. The basis behind this principle is that a party who has suffered extreme financial loss in order to save property belonging to others has the right to be compensated for such loss. The York Anchor rules control general average. Now, Your Lordships, if you could refer to page 4, line 2 of the moot proposition.
Yes.
Are you with me, Your Lordships?
Yes.
Much obliged, Lordships. It is clearly stated over here that the charter party is an NYPE form. Since the charter party is an NYPE form, clause 33, subclause A of the NYPE can be applied in the instant case. It talks about the applicability of Hague-Visby rules. The Hague-Visby rules is a set of international rules for the international carriage of goods by sea. Your Lordships, in the case of Ellis 1954 and another, the vessel had been unseaworthy before and at the beginning of the voyage. Ship owner must have complied with their obligation to provide seaworthy ship at the commencement of the voyage. Your Lordship, in this case, due diligence to make the vessel seaworthy had not been exercised by the owners because the master had failed to exercise reasonable skill, due to which there was a breach of the owner's obligation under Article 3, Rule 1 of the Hague-Visby Rules. So the defendants were not liable to contribute towards the general average. Your Lordships, in the instant case, since the vessel was unseaworthy, the vessel experienced bad weather and listed 35 degrees to starboard side, and due to which the master of the vessel jettisoned 650 metric ton of cargo of ethanol, due to which the claimant suffered loss. There was a breach of the owner's obligation under Article 3, Rule 1 of the Hague-Visby Rules to exercise due diligence to make the ship vessel seaworthy before and at the beginning of the voyage. The breach amounted to actionable fault within the meaning of York Antwerp Rule. Your Lordship, it is well-settled rule of actionable fault that loss of cargo would not have taken place if the ship owner would have provided a seaworthy vessel. The ship owner is a wrongdoer and he has to try all available methods to prevent or minimize the consequences of their own wrongdoing. The ship owner cannot be allowed to seek compensation for services done or indemnification for costs incurred in attempting to safeguard property that had been jeopardized by their own tortious behavior, and that was their own responsibility to save. Your Lordship, in the instant case, the ship owner did provide an unseaworthy vessel. The ship owner, by their own fault, occasioned the peril that gave rise to the claim. To minimize the consequences of their own wrongdoing, they jettisoned 650 metric ton of methanol in order to save the remaining cargo. Therefore, allowing the ship owner to obtain general average from the charterers would be manifestly unjust. Thus, the general average expenditure was caused by the ship owner's actionable fault. Your Lordships, due to the bad weather, the master of the vessel jettisoned 650 metric ton of methanol, which resulted in the claimant suffering cargo loss. But in the case of Union of India versus China Compania Naveria, it was held that heavy or bad weather cannot be equated to perils of the sea or act of God, because that is only a normal incident of sea voyage. Bad weather and heavy rains are not matters which are extraordinary in a sea voyage. The least expectation from a well-built vessel is to be able to meet bad weather conditions. If there is a vessel which is not able to face an unexpected event, then we can say that the ship owner did his due diligence, made the best ship. But because it was an extraordinary circumstance, the ship could not meet those extraordinary circumstances. But in the instant case, bad weather is the most expected event that can occur in a voyage. A vessel built, and if a ship cannot face bad weather conditions, it is due to the vessel being unseaworthy. A vessel built for a voyage for expected to face bad weathers and perils in its due course of original course. In this case, the ship's unseaworthiness was caused by a duty to implement due diligence. Hence, the ship owner cannot limit their obligation. Regular maintenance by the master, including essential inspections, replacements, repairs, while the cargo was in their responsibility, would have satisfied the due diligence. Your Lordships, the vessel's owner failed to exercise due diligence to make the vessel seaworthy at the start of the voyage, and this was held in the case of Cape Bonny. And in this case, neither the Chinese cargo interests nor their subrogated underwriters were liable for the cargo's proportion of general average. The vessel was unseaworthy, and the owners could not discharge the burden of proof that they or their agents exercised due diligence before and at the beginning of the voyage. Thus, the general average expenditure was caused by their own actionable fault, and they were unable to recover general average from the cargo interest. Therefore, on the basis of general average principles and your counter proofs, the respondents are responsible to pay for the loss, and subsequently, the declaration of general average is legally not sustainable in the instant case. If your lordships don't have any further questions, the council would like to seek the permission to invite the co-counsel to address third, fourth, and fifth issue.
I'm sorry, counsel, I have a lot of questions. So, in fact, the first question, when you address the first, your first issue, I specifically asked you whether you are only seeking for the arrest of the vessel or for an interim arrest of the vessel. You said yes. Now you seem to go into the merits of the case. Now, this contention is something that has to be decided on the merits. You say that the vessel is unseaworthy. There is no admission on the fact or any proof for you to show at this court at the moment to show that it is seaworthy or unseaworthy. Nothing on records. This is a matter to be decided probably in the York and Rep rule, as per the York and Rep rules, in the general average in Lloyd, London, or somewhere else. Now, why are you raising this contention before us when you actually say that you are only seeking for an interim arrest of the vessel for security?
Your Lordship, there's a presupposition that the vessel is unseaworthy.
I agree, but that's it. Why I asked you in the first place, when you are addressing the first issue, are you only looking for an interim arrest of the vessel?
Indeed, Your Lordship, the council is only looking for interim relief. The co-counsel would be dealing with this issue in length.
I believe that is a way of getting out from the further questions, counsel.
No, Your Lordship, the council does not have any such intention.
Okay, now that is one. Okay, I'll go to the
just one question to you, since you're speaking about GE and YER. Are you not bound to provide GE and the YER once it has been declared?
Your Lordship, not when the vessel was unseaworthy. And in the instant case, the jettisoning of the cargo happened due to the bad weather. And a bad weather is the most expected event that is expected to occur in a voyage. If a vessel is not fit to face the bad weather, it surely indicates that the vessel was unseaworthy. And in the cases where the vessel are unseaworthy, the charters are not liable to pay or contribute towards the general average according to your counter rules.
But general average per se is an exemption, to the normal unseaworthiness, all those things. Now, and it's a very subjective decision which is taken by the master, for which master is always given the benefit, because that's a very subjective decision which is taken by the master to save the vessel, to save the balance of the cargo. That is why general average is respected by all other cargo owners by providing the general average contribution.
Indeed, Your Lordship.
So just because the vessel couldn't resist a weather doesn't mean that it is necessarily unseaworthy. I understand your argument to the effect that yes, every vessel should be capable of sailing a weather. But it is not necessary that at all point of time it is possible. There are weather conditions. There are, lot of conditions which would have contributed to it.
Yeah, indeed, Your Lordship. Your Lordship, the vessels are made in a way to resist such weather conditions, and the facts of this case is completely silent upon this fact. And Your Lordship, the jettisoning of the cargo did happen because of the negligence of the ship owners
in providing seaworthy ships, let's put it that way.
Indeed, Your Lordship.
Yeah. Okay, if my co-judge doesn't have any further questions, we can go ahead with the other.
Nothing of the sort. I just had a doubt whether they are claiming under the CP or BL.
They are still claiming under the
and
CP.
Why they have no, like you asked.
Great, yes. Let's hear the other councils.
If the Lordships don't have any further questions, the council would like to seek permission to invite the co-counsel to address third, fourth, and fifth issue.
Sure.
Much obliged, Your Lordship. Your Lordship, it was an honor to plead before this court.
Okay.
Greetings to your lordship. If it may please this honorable court, the present counsel would like to begin.
Yes, please.
Much obliged, your lordships. Your lordships, the council will deal with issue 3, 4, and 5. Now, the present issue before the court is issue number 3, which asks about whether the court, considering this issue, would be bound by sanctions imposed by a third country. Now, your lordship, a little background here. The Octa Limited, the claimants here, insured their cargo from an insurance company. And this insurance company also obtained a letter of subrogation, which essentially gives this insurance company legal rights to pursue the insurance claims against respondents. Interestingly, this insurance company is also enlisted in SDN list. Now, your lordship may ask, what is this SDN list? SDN list stands for Specially Designated Nationals
Can
List.
I pause you? Can I pause you for a moment? Where did you get these facts from?
Your lordship, if your lordship could refer to page number 4, para 2
Yes.
of the moot proposition.
Page number 4.
Para
Okay.
2.
Okay. Okay. Continue with it because I didn't remember reading it. Must be my mistake. Yeah. Continue
Indeed,
with
your
the
lordship.
argument.
So, your lordship, SDN list stands for Specially Designated Nationals, which is issued by Office of Financial Assets and Control in the US. Now, the assets of such entities enlisted under SDN list are blocked, and only US persons are generally prohibited from dealing with such entities. Your lordship, this SDN list serves as a secondary sanction with no jurisdictional link. And when there is a secondary sanction of this nature, it is usually unilaterally imposed and is meant to deter a third country from transacting with the sanctions target. Moreover, your lordship, in 2002, UN General Assembly adopted a resolution calling on states to not recognize unilateral sanctions imposed to which India was a party to. India itself has argued that such unilateral sanctions should be eliminated as it infringes upon a country's right to economic and self-development. Your lordship, SDN list is issued by an enforcement agency of the US, which has again no jurisdictional link. So the next logical question is, why should this SDN list affect the jurisdiction of this court in India? Your lordship, for the sake of argument, let's take this example. Say tomorrow, USA's enforcement agency declares that a company as big as Amazon is been enlisted in the sanctions list. Now, does this prohibit India from dealing with business, from dealing with Amazon at all altogether? Does this mean that Amazon as a company has been disreputed in the entire world? Certainly no, because just because a sanctions list has enlisted Amazon in their prohibited list does not mean that the entire company has gone bad or has been impugned. Your lordship, moreover, as long as there does not exist any comparable sanctions in India to prohibit the citizens or companies from doing business with the targeted party, these sanctions often are just mere imposition of extraterritorial application of domestic laws. Therefore, the council contends that this code would not be bound by sanctions imposed by a third country. Your lordship, it is also pertinent to note that these sanctions raise difficult questions in terms of restriction on the exercise of jurisdiction of state power. In the instant case, the court also needs to consider that the unilateral imposition of sanctions, such as the SDN list itself, in the absence of any judicial scrutiny, makes it an arbitrary exercise of power on the part of the sanctioning state. These sanctions, more often than not, serve to further a state's foreign policy objectives. When there is no jurisdictional link, it is imperative that the legal scrutiny of such secondary sanctions is there. If your lordship, does not have any question, the council would like to proceed to the next issue at hand,
No,
that is
just
issue number 4.
two questions that I have. One is with regard to the
Please.
sanction that you're. Does the fact say that the sanction is imposed by a single country and not by? It was not imposed by or not accepted by the country which the court is hearing the jurisdiction. Does it say that?
Your Lordship, the council understands the concern. However, to answer that question, the laws of Indo are paramount to the laws of India. As of now, India does not subscribe to SDL list, as was argued by the council that SDL list is issued by Office of Financial Assets and Control in US. Now, this is an enforcement agency of US, which prohibits the companies and people in US from dealing with the sanctions target. So these sanctions are mere application of extraterritorial application of just domestic laws. If that answers your Lordship's question.
Yes, I mean, I just wanted to be clear on the facts because I wasn't.
Proceeding to the next issue, your Lordship. For the fourth issue, the council contends that the court cannot adjudicate on the rival claims even if the alleged damage occurred within the territorial waters, as a rival claim of GA contribution has to be necessarily settled in arbitration at Lloyd's, London. Now, your Lordships, before moving to the argument, the council would like to clarify that the original claim here is the claim of short delivery of cargo, which was raised by Octa Limited, that is the claimant here. And against this original claim, a counter claim was raised by the owners demanding GA contribution. Now, for the sake of clarity, the council will deal with this issue in a twofold manner. Proceeding to the first limb of the argument, insofar as the short delivery of cargo is concerned, the plenary powers of this honorable court enables it to adjudicate on claims of short delivery of cargo. Now, if your Lordship may refer to para 8, page 3 of the moot proposition. Are your Lordships with me?
Page 3 of the moot proposition.
Indeed, your Lordship. Page 3, para 8.
Yeah, you could go ahead.
Your Lordships, it is evident that after jettisoning of the cargo, the survey report found that the delivery of cargo was actually short of 650 metric ton of methanol. Not 500, not 600, but 650 metric ton of methanol, as opposed to what the owners of the MV Moonlight contended. Now, your Lordships, in the instant case, it relates the principle of admiralty jurisdiction as given under Section 3 of the Admiralty Jurisdiction Act 2017. Which applies to all vessels, and I quote, all vessels operating in Indian territorial waters, regardless of the owner's location or domicile, meaning thereby that the vessel Moonlight is in the jurisdiction of this honorable court. Now, on the account of short delivery of cargo, it is argued that by the virtue of the powers vested in the court under Section 4, Subclause D and Subclause F of the Admiralty Jurisdiction 2017 Act, the petitioner's claim of short delivery of cargo can be adjudicated upon by this court. This honorable court has the jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of loss or damage caused by the operation of vessel. The council would also like to draw your Lordship's attention to the landmark judgment of MV Elizabeth versus Harvan Investment Trading case, which can be found on page number 241, para 66 and para 67 of the compendium. The findings of the case corroborates the council contention here. Page 241, para 66 and para 67. Your Lordship, in this case, it was held that the High Courts undoubtedly possess jurisdiction over claims of cargo movement and that the power of the court is unlimited and plenary unless it is unless it is curtailed by necessary implication. Now, moving to the other limb of the argument, Your Lordship, it is argued that the adjudication on GA contribution is dependent on the principle of party autonomy and has to be necessarily settled in arbitration at Lloyd's London. It is pertinent to understand that this court has the authority to decide on maritime claims only to the extent of short delivery of cargo, but not to the extent where it can also adjudicate on the issue of GA contribution. Your Lordship, in the Charter Party Agreement, specific reference has been made to the arbitration clause by use of the expression, and I quote for the benefit of the Honorable Court, any dispute regarding GA has to be settled in arbitration at Lloyd's London, as given on page 4, para 10, line 3 of the moot proposition. Your Lordships, on a plain reading of this arbitration clause in the Charter Party Agreement, it can be understood that there is no manifest inconsistency or insensibility for that matter. And the intentions of the party was very clear that the disputes relating to GA arising thereunder should be resolved by arbitration according to the clause in the Charter Party Agreement. The Council would also like to emphasize that arbitration is based on the very principle of party autonomy. Your Lordship, the principle of party autonomy says that the parties to a contract have the freedom to determine applicable law to govern their dispute. Now, it is pertinent that the court considers the independence given to parties to choose the venue of the arbitration to settle disputes while adjudicating on the rival claims of GA contribution. Your Lordships, in the instant case, both the parties have mutually agreed that the venue of the arbitration shall be Lloyd's London. Now, considering the agreement of the parties having Lloyd's London as their venue, it is implied that the intention of the parties was to exclude all other courts. Now, wherein an arbitration clause is already stipulated in the Charter Party, principle of party autonomy vis-a-vis the court's intention in the agreement, court's intervention in the agreement should supersede and should be given priority at all times, as principle of party autonomy is the brooding and guiding spirit in arbitration. So to conclude, it is pertinent that the exercise of admiralty powers should be limited only to where parties' agreement is unenforceable by any standard. And therefore, the dispute regarding GA contribution should be settled at arbitration at Lloyd's London. Now, Lordships, if your Lordships do not have any questions, the Council would like to proceed to the fifth and the last issue.
No, let's make some things clear here. Now, your co-counsel was started with the argument stating that as far as the interim, since the vessel is here, interim, she would like to have a security of the claim and said that you people will not be contesting on merit. Subsequently, you people went on to contest everything on merit. Now, let's assume for a moment that this court is assuming jurisdiction, irrespective of there being an arbitration clause. Okay, you are submitting yourself to the jurisdiction of this honorable court and want the short delivery of cargo to be determined here. The GA or the counterclaim that is being claimed by the owner also arises from the same action to which you want this court to adjudicate. That being the so, why should this court only refer the GA matter to arbitration and not your matter also? The other dispute also to short delivery also to it's either both the matters would be decided together or both the matters would be decided in arbitration. Anyway, there is arbitration clause separately. Your contention is that your matter supersedes the arbitration clause, whereas the other matter should be heard in arbitration. Don't you think that's an unfair argument to take?
Your Lordship, the Council understands what your Lordship is trying to get at. To answer that, your Lordship, the Council would like your Lordship to refer to the Admiralty Jurisdiction Act of 2017, section 4. If your Lordship may allow, the Council would like to read
No, it's okay. That's lays down the maritime claim,
the
and
said
yes,
section.
I agree. So, what is the contention that you're?
Uh, Your Lordship, Section 4 under Admiralty Jurisdiction Act talks about a maritime claim. Now, here it is pertinent to understand that the dispute regarding GA is a counterclaim by the opposing party. The jurisdiction, the dispute over GA contribution is a counterclaim that has been raised by the opposing party, and for that GA contribution, for the disputes of GA contribution, there is a separate charter party clause. If that makes sense. So, for insofar as short delivery of cargo is concerned, Section 4, subclause D and subclause F are governing the issues related to maritime claims. But when it comes to GA contribution, the presence of arbitration clause here determines that it should be arbitrated under Lloyd's London.
If I
Moreover,
try
Your
to
Lordship,
understand, no, if I try to understand your argument, you're saying that your claim is a claim and the other claim is a counterclaim, and hence it cannot be taken because your claim falls under maritime claim, and other being counterclaim, it cannot fall under maritime claim. Is that what you are trying to argue? Or that's what I understand from what you argued.
yeah, not just that, Your Lordship, it is also pertinent to understand that the principle of party autonomy cannot be repudiated.
Party
The
autonomy
parties,
I agree. So if you're speaking about party autonomy, let party autonomy goes to both your case and the other counterclaim case. Both of you go and arbitrate in the forum or the arbitration venue where you both have agreed to. You can't take a stand where in one place you are saying that no, we are submitting to your jurisdiction, and the other claim you are saying that no, it amounts to a counterclaim. It can't be, irrespective of you submitting to the jurisdiction of this honorable court. You're before this honorable court, you want the arbitration of the matter to be decided by this honorable court, but you don't want the counterclaim to be decided by this honorable court.
Your Lordship, the council understands your concern. However, it is, Your Lordship, the arrest of the cause of action here is the arrest of vessel, which is inherently an action in rem. Now, the subsequent maritime claim arose because of the apprehension of loss of cargo by the petitioner, by the claimants, that is Octa Limited.
Council, just let me pause for a moment. Right now, is the action that you are arguing is it an action in rem or an action in personal?
Your Lordship, the
Right
arrest of
now,
vessel, or
right now, when you argue this position, are you actually standing in the foot of action in rem, or the owners, are they standing in the shoes of action in rem or in action in personal?
Your Lordship, arrest of vessel is action in rem, which
Yes.
is non-arbitrable. Hence, the petitioners have invoked this court's jurisdiction.
I agree. So after the arrest, once the security is made, the action in rem actually converts to an action in personal.
Action personal. Indeed,
You are arguing the case here right now, and now there is no action in rem right now. There is only action in personal. The owners are in picture. They are also arguing the matter. So the action has actually converted from action in rem to action in personal. So you can't now you want this, and now you are submitting to the jurisdiction of this honorable court. So now don't take the argument that it was all on action in rem. That stage is over. The vessel was arrested. Once the security is given, the suit changes from action in rem to action in person.
Your Lordship, to answer that, the council understands what your Lordship is trying to say. However, in if your Lordship could refer to your Lordship, if your Lordship could refer to page 123, para 48 of the compendium. Your Lordship, in a sense, in in the judgment of Altis Uber, it was held that the mere existence of an arbitration clause does not oust the jurisdiction of this court to decide on maritime claims. So herein, taking reliance from this judgment, the council is trying to contend that as insofar as maritime claim is concerned, which this court is competent enough to adjudicate on, it should be settled here. But when it comes to GA contribution, the matter should be referred to arbitration. And since, Your Lordship, the cause of action arose in India. So in India, in the territorial jurisdiction of this court. So why should the interim relief, the cause of action, which actually in turn gave rise to, as Your Lordship mentioned, the dispute over maritime claim, the short delivery of cargo. The original claim was an action in rem which arose in the territorial waters of India, and jurisdiction, and then Admiralty Jurisdiction Act of 2017 confers this Honorable High Court with the powers to adjudicate on the maritime claims when under Section 3. So the territorial waters when the vessel is in territorial waters of India, the maritime claims should be adjudicated upon by here, and therefore they cannot be referred to arbitration at Lloyd's London, because then the laws of London will be governing that. Herein, the cause of action arose in Indian territorial waters, and under Section 3 of Admiralty Act 2017, the maritime claims of short delivery of cargo should be adjudicated upon by this honorable court. If that answers Your Lordship's question.
Still, there are doubts, but I'm not revolving around it. You could go to the other case. I'll just if my co-judge doesn't have any further questions on this. Yes.
No, I was having a doubt regarding the same issue that we discussed right now, but then also regarding the SDN, which he has talked about. Let me have one clarification upon it. Since a subrogation right holder is an SDN entity, how can how can you say that if I say that the entire legal action is hit by secondary sanctions, how do you convince?
The council begs your ladyship's pardon. If your ladyship could just rephrase that question.
The subrogation right holder is an SDN entity, right? So if I say that the entire thing is entire legal action is hit by the secondary sanctions, no, how will you convince?
Your Lordship, your ladyship, the council is present here before this court on the behalf of petitioners, not on the behalf of the insurers. Moreover, if and when this action would arise on the behalf of the insurers, then this issue would be taken up there. Also, here, your ladyship, the facts of the case are silent on what grounds has the US authority enlisted the insurance company under the SDN list. We don't know that yet. Moreover, this is a unilateral imposition of sanctions, because herein there is no manifest link between the authority imposing the sanctions and the sanctioning state. The party, the US here is a third country, and herein we are concerned with the Kingdom of AEU and Kingdom of Indo. So there is no jurisdictional link. This is what the council is trying to contend. If that answers your ladyship's question. If your lordships do not have any further questions, the council would now like to proceed to the fifth issue.
Yes.
And the final issue. Your lordships, the fifth issue deals with, do the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitrable? Now, for the fifth issue, the council argues that the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitrable. Arbitration Act in its provisions recognizes that disputes on certain subjects are not capable of being arbitrated. although these subject matters are not enumerated or categorized in the Act itself. But the courts of India, by virtue of its judgments over the years, have formulated principles of non-arbitrability. Firstly, the apex court in the landmark judgment of Booz Allen and Hamilton versus SBI Home Finance Limited held that an action in rem is unsuitable for arbitration and thus is considered as non-arbitrable. If your lordships may refer to page 277 of the compendium, para 23, it was laid down by the court that all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals, being unsuited for private arbitration. Now, your lordships, it should be understood that an action in personam determines the personal rights and interests of the parties listed in the case. But actions in rem are aimed against a property and determines the party's rights exercisable against the world at large.
Your
of the General
lordships,
Republic.
sorry for the interruption, but the time allotted to speaker 2 is already over.
Yeah, Granda, finish your argument. Speaker
Oh,
two.
yes, your lordship.
Indeed, your lordship.
1 minute. Granda, 1 minute.
The council
Yes, your
will
lordship.
take this court 30 seconds to wrap up with the fifth issue and proceed to prayer, if that's
Yes.
permissible, your lordship.
Finish your argument in 1 minute.
Indeed, your lordship. Your lordship, furthermore, in the findings of A.I.R. Swami versus Parma Sivan, the court held that even in the presence of a mutually decided arbitration agreement between the parties, a dispute matter related to an action in rem will be considered as non-arbitrable. Thus, the council concludes that the present dispute that relates to the arrest of vessel, which essentially is an action in rem, is therefore non-arbitrable. If your lordships do not have any questions, the council seeks permission to proceed to prayer.
I have questions, but there is no time.
Uh,
You can go
Your
to prayer.
lordship, the
Yes,
Begs.
please go ahead.
Okay. In the light of the issues raised and arguments advanced, may this honorable court be pleased to adjudge that the exercise of admiralty jurisdiction, despite the presence of an arbitration clause, is valid. Declare that the general average is legally unsustainable if the vessel is unseaworthy. Declare that the rival claims cannot be adjudicated upon by this court, even if the alleged damage occurred within its territorial waters. Declare that the Arbitration and Conciliation Act excludes an action in rem from its purview as non-arbitrable, and pass any other order which this honorable court may deem fit in the furtherance of equity, justice, and good conscience. And for this act of kindness, the petitioner shall, as in bound, ever duty pray. Your lordships, may the present council add that it indeed was an absolute privilege to plead before this honorable court. Much obliged, your lordship.
If your lordships are pleased, I would like to invite the first speaker for the respondents to speak.
Yes.
So, speaker 1, IMC 109, your time starts now.
Before starting, can you please check your audio? I'm sorry, but you're not audible. I'm sorry, you're not audible. Can you please try to connect from some other device? Your voice is breaking, so we can't hear anything that you're saying. So can you please try to enter from the other device?
I think there is some issue with the network connectivity there or something like that. Maybe they may have to switch on from another device or try to check the connectivity also.
Counsel seeks the leave of the court to address your lordship and your ladyship as your lordship.
Yes, that is audible. Thank you so much.
Yeah. Counsel seeks the leave of the court to reset the time given to the speaker due to the unforeseen circumstances that occurred.
Yes.
Most grateful, your lordship. Your lordship, I am Amuda Kolawole Ibrahim, and with me is my co-counsel, Fabumi Boluwatito. Together, we announce our appearance as counsel for the respondent in this case. Your lordship, I'll be addressing the issue, the merits of the first, second, and third issue, while my co-counsel will address the merits of the fourth and the fifth issue. We would also, while doing this, respond to the arguments as laid by the petitioner. Counsel seeks the leave of the court to proceed.
Please.
Most grateful, your lordship. Your lordship, commencing with the first argument, as regards whether or not the exercise of admiralty jurisdiction by the court is valid, the respondent answers in the negative, that this court lacks competence and cannot adjudicate on this matter before it. And our position is premised on Article 7 of the International Convention on the Arrest of Ships, 1999, which provides, and I read, that the courts of the state in which an arrest has been effected or security provided to obtain release of the ship shall have jurisdiction to determine the case upon its merits, unless, your lordship, unless the parties validly agree or have agreed to submit the dispute to a court of another state which accepts jurisdiction or to arbitration. Furthermore, your lordship, cementing the fact that this court lacks competence to sit on this matter is the provision of Section 2, subsection 2 of the Arbitration and Conciliation Act 1996 as amended 2015, which provided that where parties have agreed to the contrary, the parties to an international commercial arbitration with the seat of arbitration outside India cannot approach the Indian court for interim relief. Your lordship, also on the issue of jurisdiction, Section 8, subsection 1 established the fact that the judicial authority must refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Your lordship, relating this to the fact of the case, it was expressly provided for that arbitration would be in London for resolving all dispute between the petitioner and owners and parties interested in the Moonlight vessel. The presence of this arbitration clause excludes this matter from the jurisdiction of this honorable court. Thus, we humbly submit, your lordship, that this court lacks competence and cannot adjudicate on this matter before it, because the very statute that vests this court with its jurisdiction excludes it in instances where parties have agreed to submit the dispute to an arbitral tribunal. Counsel seeks to proceed to the second argument if your lordship has no questions for me.
Just one question to you. Since
Okay,
the
your lordship.
arbitrators have no right to arrest a vessel, then what is wrong with the arrest proceedings? Could you please explain?
I did not get your question, your lordship.
The arbitrators have no right to arrest a vessel. Then what is wrong with the arrest proceedings?
Your lordship, the fact that the vessel is in the territorial waters of the state of Indo empowers an admiralty court to actually secure arrest of vessel. However, I'll refer this court to the provisions of Section 9, subsection 2 of the Arbitration and Conciliation Act 1996. Permit your lordship to read the section before this honorable court. It provides that sorry, your lordship.
Yes, we can hear.
It provides that where before the commencement of the arbitral proceeding, a court passes an order for an interim measure of protection under subsection 1, the arbitral proceedings shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine, Your Lordship. This shows that regardless of the fact that the vessel was in the west coast of Indo at this time and within the territorial waters of Indo, which gives this court jurisdiction, the provisions of section 9.2 ensures that the case still goes back to arbitration, Your Lordship.
No, the learned judge asks, what is now, as far as arresting the vessel is concerned, the arbitration or providing an interim measure is concerned, the arbitral tribunal may not have that kind of power. Whereas, and now there is one thing also clear. The vessel was within the jurisdiction of the territory of Indo and within the jurisdiction of this honorable court. And it is also admitted in the, as per the facts, that the Admiralty Jurisdiction and Settlement of Maritime Claims Act is applicable to the state of Indo, right? There is no dispute on that. Now, if you have a domestic act, it actually supersedes the international convention. So your contention on your argument, which was raised based on the 1999 convention, may not hold good because the act per se provides an interim measure within the state of Indo. So how would you get over that?
Thank you, Your Lordship, for this question. Your Lordship, I refer you to section 8, subsection 1, which the position of section 8, subsection 1 of the Arbitration and Conciliation Act 1996, as amended in 2015, which is binding, states that judicial authority must refer parties to arbitration unless it finds that prima facie no valid arbitration agreement exists, Your Lordship. In this instant case, an arbitration agreement exists. Thus, this case should be in the first place with an arbitration tribunal and not within the jurisdiction of this court, Your Lordship.
What about providing an interim measure under section 8 of the arbitration?
I did not get your question, Your Lordship.
No, why can't we give an interim measure, like providing a security towards arbitration by arresting the vessel? What prevents us from exercising the jurisdiction to that effect? As per section 9, even as per section 9, it says that there is a provision for interim measure.
Yes. I want to refer you to, permit me, Your Lordship. I want to refer you to section 5 of the Arbitration and Conciliation Act 1996, as amended 2015, which provides that notwithstanding anything contained in any other law for the time being in force, in matters governed by this act, no judicial authority shall intervene except where so provided in this act, Your Lordship.
I agree. That is with proceeding with the arbitration, right? I'm speaking about an interim measure.
As regards the interim measure, Your Lordship, it is within the powers of this court. That is why the provisions of section 9, subsection 2 is clear. It provides that even after an interim measure has been obtained from the court, the parties must be referred within an arbitral tribunal within 90 days, Your Lordship.
That is something that is not stated in the facts, right? Whether you have, and let me put it another way. Now you are saying that all the matters has to be decided as per the arbitration clause. That is your argument. But then you are submitting to the jurisdiction of this honorable court by making a counterclaim. So if once you make a counterclaim, you are submitting to the jurisdiction of this honorable court. Your entire argument goes that it has to be decided somewhere else.
Your Lordship, the strength of our argument, basically what we are arguing before this honorable
I believe
court,
the case of counterclaim is also decided by you. No, it's not argued by you, right? Okay. I'll hear your co-counsel on that. Okay, you could proceed with your second contention. I believe if my co-judge doesn't have any.
Proceeding with the second issue, Your Lordship, as to whether the declaration of general average is legally sustainable if the vessel is unseaworthy. The respondent answers in the affirmative that the declaration of general average is legally sustainable, even if the vessel is unseaworthy, Your Lordship. And our position hinges on Rule A of the York Antwerp Rules 1994, which asserts today that there is a general average when a sacrifice is made for common safety and for the purpose of preserving for peril. Your Lordship, Rule A of the York Antwerp Rules laid out 4 essential requirements for an action to fall under general average. 1, Your Lordship, the expenditure of sacrifice needs to be extraordinary. 2, Your Lordship, the act must be intentional. 3, the action must be for the common safety. And 4, there must be a peril. Relating this to the fact of the case, Your Lordship, the sacrifice made by the respondent to ensure that the ship is not lost at sea is one that is extraordinary, Your Lordship. And it was also an intentional act, which meets the second requirement. Also, the act was in the common safety of the lives of people on board and the goods on the vessel, Your Lordship. Also, if the respondent had failed to carry out the task which he did, it would have led to the peril of the vessel in question, which the 4 requirements laid out by Rule A of the York Antwerp Rules fits into this case, Your Lordship. Your Lordship, the new NYPE 2015, particularly clause 33, subclause C, entitles the respondent to receive general average contribution even when the respondent fails to exercise due diligence to make the ship seaworthy. Your Lordship, the petitioner have argued, particularly paragraph 14, page 4 of their brief of argument, that the ship owner failed to exercise due diligence to make the ship seaworthy. However, Your Lordship, by virtue of clause 33, subclause C, it allows the respondent to still receive general average even when he did not exercise due diligence. And in this case, Your Lordship, the unseaworthiness did not give rise to the claim in general average, which is the exception to the rule under clause 33, subsection C. It was never stated, either expressly or impliedly in the statement of fact, Your Lordship, that the unseaworthiness led to
We can't hear you. We can't hear you. Counsel, we can't hear you. Your phone is stuck.
No, I'm sorry, you're not audible.
It's muted.
Sorry, team of IMC 109. We can't hear you through this system that you have logged into. Can you please try logging into some other system? Your Lordship, sorry for the delay. There has been some technical issues. We will solve it as soon as possible. Team IMC 109, please try to fix it. No, you're not audible. No, we can't hear you. We cannot hear you.
Could you just try from the other phone which you were just using now? Not the system, the phone. It was clear right now. So the other phone, the other device, could you just try from that?
Team IMC 109, if you have any urgent messages, please send it in the chat box. IMC 109, can you please log in using some other device? Team 109,
Your Lordship, can you hear me?
yes, you're on.
Sorry for the break in transition, Your Lordship.
Yes, you may continue.
Now, I'll continue to argue the merits of the second issue. Like I said, Your Lordship, Clause 33, subclause C provides that the respondents can still receive general average even when they do not exercise due diligence to ensure that the vessel is seaworthy. And the petitioner's argument, particularly paragraph 14, page 4 of their bit of argument, they argued that the ship owner failed to exercise due diligence to make the ships unseaworthy and thus is not entitled to a claim in general average. However, by virtue of clause 33 subclause C, it allows the respondent to receive general average even when they did not exercise due diligence. And in this case, Your Lordship, the unseaworthiness did not give rise to a claim in general average, which is the exception to clause 33 subclause C. And this is because the vessel was seaworthy at the time when the contract was signed, and there is nothing in the agreed fact that points to the fact that the respondent was in fact negligent during the voyage or before the voyage started, Your Lordship. Your Lordship, I want to draw your attention to Article 4, subsection 1 of the Indian Carriage of Goods by Sea Act 1925, which provides that neither the carrier nor the ship shall be liable for loss or damage arising or resulting from unseaworthiness unless caused by want of due diligence on the part of the carrier to make the ship seaworthy. Once again, Your Lordship, in the statement of fact, what was said was that the ship experienced bad weather. Your Lordship, I want to bring to the attention of this court that bad weather, it can never be controlled by any man. Thus, bad weather is an act of God, is an act uncontrolled by anybody, and is an act that can affect anybody. Bad weather does not question the seaworthiness of this vessel, because by the time the voyage started, the by the time the voyage started, the the vessel was in fact seaworthy. I also want to bring the attention of your Lordship to I also want to bring the attention of your Lordship to Article 4, subsection 2 of the said Indian Carriage of Goods by Sea Act 1925, particularly subsection C, which provides that neither the carrier nor the ship will be responsible for loss or damage arising or resulting from the perils, dangers, and accidents of the sea or other navigable waters. Your Lordship, the claimant's breach of a fundamental term in the agreement in the claim picture where he ordered the seal to
Sorry to
sail
interrupt your lordships, but okay, they've just on the audio. The video was off all while. If you all had any problem with that, is that okay with you all?
It's okay.
Okay, your lordship.
It was due to network issues, your Lordship.
Continue with the argument.
The claimant breached to the express a fundamental term in the agreement, that is the claim feature, by ordering the vessel to sail to an unsafe port, thereby putting the vessel at risk, your Lordship, at risk, and thus jeopardizing the fitness of the vessel for the time charter. It shows that the claimant, the petitioner in this case, needs to pay the general average as declared, your Lordship. Your Lordship, the maximum of equity.
Counsel, let me stop you for a moment. These arguments, these are not there in the facts, right? You sending it to a foreign country would amount to unseaworthiness. Are these even there in facts? I mean, like, there's nothing in facts to say that sending it to the port of Liran has caused the vessel to be unseaworthy. Let's no. I mean, it's all hypothetical situations. Let's not go on arguing on those grounds.
Your Lordship, I want to bring to the attention of this court the maximum of equity, which says he who comes to equity must come with clean hands, your Lordship. Your Lordship, BLK Liran was a place known for political unrest at that time and was within the jurisdiction of the military at that time. That means, your Lordship, that there would be checkpoints, and the vessel proceeding to BLK Liran would have led to the military stalling this vessel and preventing it from reaching the west coast of Indo at the time it should have reached the west coast of Indo. We're arguing, your Lordship, that petitioner in this instance case had not asked the respondent to proceed to that place known for political unrest. It would have gotten to the west coast of Indo earlier than it did. It would have beaten the bad weather, which caused the unseaworthiness, your Lordship. And the ship was in fact not unseaworthy at the time of the voyage, your Lordship. Your Lordship, Rule 2 of the York Antwerp Rules of 1994 provides that loss of or damage to the property involved in the common maritime adventure by or in consequence of a sacrifice made for the common safety and by water which goes down a ship hatch opened or other opening made for the purpose of making a jettisoning for the common safety shall be made good as general average. Your Lordship, the respondent humbly submits that the claim for general average is legally sustainable, your Lordship. Your Lordship, this is just fact that the premise of the petitioner's argument that the respondent failed to exercise due diligence in ensuring that a ship is seaworthy holds no water, because the clause 33 subclause C gives rights to the owner, your Lordship, to receive general average contribution even if he fails to ensure that the ship is seaworthy, your Lordship.
You seem to argue that the ship is seaworthy. How do you prove it?
I do not get your question, your Lordship.
You seem to argue that the ship is seaworthy. How do you prove it?
Proving that the ship is seaworthy.
Let us put it in a different way. I'll take the argument which was stated by the counsel for the claimant. Now, they have also quoted one of the judgments wherein it is stated that bad weather cannot be treated as every vessel should be capable of sailing through a bad weather, because bad weather is an event which is always happening in the sea. So just because there is a bad weather, you can't claim that there is a jettison or a general average being declared. Now, if the vessel is not capable of sailing through a bad weather, that means the vessel is not seaworthy. How do you prove that it was seaworthy? Your entire argument goes on to the fact that it was seaworthy.
Your Lordship, before a ship is said to be seaworthy, before it begins a voyage, it must show that it is actually safe to travel. And this is done based on documents that would definitely be in the claim fixture submitted to the petitioner, Your Lordship. This document shows that the ship is safe to travel and that the petitioner could in fact trust the respondent to transport his goods. The fact that the ship was safe at the beginning of the voyage and actions actions beyond the control of the respondent led to the ship having issues at sea shows that in fact it was indeed seaworthy in the first place, Your Lordship.
Yes, that is probably an argument to take. That vessel being one time charter. Okay, but now again, I have a issue with this thing. You were stating that there was negligence, or the claimants were trying to actually put the vessel in bad risk while they actually made you to travel to the port of Laran. Now, the vessel was on time charter. If you actually know, it was on time charter. So there was no obligation for you to go to the port of Laran if you actually anticipated any risk to the vessel, because the vessel was not on bareboat charter but on time charter. So in all possibility, you had the operational control over the vessel, or you were in charge of the vessel. So it is only for not taking the other argument. But then coming to clause 33C, it speaks about claiming the general average contribution if you have exercised due diligence. Okay. Now, unseaworthiness is not a due diligence if you actually look at it. Seaworthiness of the vessel is an absolute duty which is to be given by the or rather that is the only duty that is to be guaranteed by the owner of the vessel. Now, once the claimant says that unseaworthiness, take the contention of unseaworthiness, then you can't actually, I have my doubts whether you can take the claim of clause 33C, because it is not due diligence unless and until, because it's a negligence. Unseaworthiness amounts to negligence.
Your Lordship, clause 33 subclause C provides that the owners are entitled to receive general average, even if they fail to exercise due diligence. However, even if they fail to exercise due diligence in making this vessel seaworthy, it is the exception in clause 33C that makes it special, Your Lordship. It says that provided that the casualty giving rise to the claim of general average, Your Lordship, is not caused by such unseaworthiness. Interpretation of that, Your Lordship, which I know you would do justice to, Your Lordship, is the fact that even if the respondent fails to exercise due diligence in making the ship seaworthy, as long as the actions that led to the loss of cargo is not as a result of the unseaworthiness, the respondent is still entitled to a claim in general average, Your Lordship.
Yes. You could go to the third argument also, because you have it to complete. There's no time.
Yes. Commenting with the third argument as regards to whether the court considering the issue is bound by sanctions imposed by a third country. The respondents have raised in the affirmative, your Lordship, and our position hints on the Arbitration and Conciliation Ordinance 2015, which clarifies in Section 17 of the Act that orders passed by arbitral tribunals would have the same effect as that of an order passed by a court, by this, just like this honorable court, your Lordship. Your Lordship, if just like the statement of fact has said, if this case goes to arbitration, an arbitral award will be given, which is also binding on the parties. And this court would actually enforce such arbitral awards, your Lordship. That's why the court, this honorable court, is bound by sanctions imposed by a third world country. Your Lordship, Section 9, subsection 3 of the Arbitration and Conciliation Act 1996 provides that the arbitral tribunal, once an arbitral tribunal is constituted, the court will not entertain an application under subsection 1 unless it finds that the arbitral tribunal does not do justice efficaciously to the provisions of section 17. And that's when the court can enter into the matter in the interest of justice. Your Lordship, in this instance case, the case have not even gone to the tribunal, and the matters before this only court actually matters, just like the claim for short delivery of cargo, the claim for general average are matters that can actually be arbitrated by an arbitral tribunal, your Lordship. If this case goes to arbitration, your Lordship, this court is bound to actually enforce the decisions of the arbitral tribunal. Your Lordship, an important rule in law is the rule of contract that demands that a contract is binding between parties, your Lordship. If parties are not allowed to respect the rules of contract, it questions the total essence of justice, your Lordship. This is where the Latin maxim pacta sunt servanda comes into play, your Lordship. In this is like we pray, Lordship, we humbly submit, your Lordship, that this court is bound by sanction imposed by third world country, and we ask God to respect the agreement between those parties and refer them to an arbitral tribunal. If there's no more questions for the counsel, I will defer proceedings to my co-counsel to argue the merit of the fourth and the fifth issue, your Lordship.
No, we don't understand why a sanction which is being unilaterally imposed by one country should be accepted by a country, by this country, and why should it preclude by the jurisdiction of this honorable court?
I don't get your question, your Lordship.
No, the sanction which is imposed unilaterally or without the consent from this country, why should it actually take away the right of this court to exercise jurisdiction of this honorable court to hear this matter?
Put it in a different way. Do the sanctions apply to courts also?
Yes.
Secondary
The sanctions-
sanctions, does it apply to courts also?
Indeed, your Lordship, it does apply to courts.
Now that is something you will have to substantiate on how a secondary sanction would apply to a court, or how is a court bound by a sanction. Trade, I can understand.
Your Lordship, the sanction in this instance case, your Lordship, is the arbitral award that would actually be given by the arbitral tribunal, your Lordship. This court is actually bound to actually enforce the arbitral award between the parties, your Lordship.
Okay. So your time is up. The second speaker can come forward and.
Most graceful, your Lordship.
Once again, your Lordship.
Your Lordship, before we go into the next set of arguments, I would like to say that we have, without counting the technical problems, there has been an excess of 3 minutes, 30 seconds. So
That
if
is
the
fine.
second speaker would, that's okay. Okay, Your Lordship.
Give them the same amount of time.
Yes, Your Lordship.
Counsel seeks the leave of the court to proceed, Your Lordship.
Yes.
Most grateful, Your Lordship. Once again, Your Lordship, my name is Fabumi Boluwatito. I will be addressing this honorable court on the merits of the fourth and the fifth issues.
Okay.
The fourth issue, whether the court can adjudicate on the rival claims, considering the fact that the alleged damage occurred within its territorial water. The cargo claims and demand for the general average contribution are within the rights of the arbitral tribunal to arbitrate upon, pursuant to the dictates of the New York Produce Exchange Form, which can be regarded as the most widely used standard time charter party in the cargo sector. Your Lordship, this is also recorded in the York Antwerp Rules of 1994. The nature of the arbitral process, it means that in the vast majority of cases that proceed to arbitration, the use of the court is excluded entirely, which is against what the petitioner is raising and what we are doing in Your Lordship, Honorable Court. Your Lordship, looking at the fact of the case, line 39 to 44, where the petitioner claimed for short delivery and demanding the general average contribution, it is only accurate that the dispute must be resolved by the arbitral tribunal, and it alone has the jurisdiction to arbitrate on the rival claims. Your Lordship, it is important to bring to the attention of this honorable court that there is a valid arbitration agreement between the parties. Such agreement is binding on both parties and the court. To this, Your Lordship, the respondent firmly submits that the court, not being a meddlesome interloper, cannot adjudicate on the rival claims. If there's no question, Your Lordship,
No, so
like
basically, you are also supporting the argument of the claimant to the effect that there cannot be a counterclaim.
Your Lordship, I didn't get that.
No, are you supporting the argument of the claimant to the effect that there cannot be a counterclaim before this honorable court, and it should be decided in arbitration?
The respondent advised in the negative, Your Lordship.
In
Yes, Your Lordship.
which is actually
the
you're
court
saying that it
retain-
should be you're saying that the counterclaim should also be decided in arbitration.
No, Your Lordship.
Yes.
What I mentioned is that the court cannot retain its jurisdiction to adjudicate the substantive claim because a valid arbitration agreement exists between the parties.
I agree. The issue in hand is whether, since the claim for short delivery of cargo is raised before the court, whether a counterclaim is also raised by the owners demanding GA contribution, whether the court can adjudicate on the rival claims.
Yes, the court cannot. It should be taken to the arbitral
So
tribunal.
you're supporting the argument of the claimant.
No, Your Lordship. I'm giving my argument based on the use of the arbitral process, that it is
I agree.
not.
I agree. I'm not on that. This is the same claim that the claimant also raised. The claimant is also stating that the counterclaim cannot be raised before this honorable court. The claim of counterclaim cannot be taken before this honorable court and should be arbitrated in Lloyd's London. That's exactly the claim that is being taken by the claimant also.
Your Lordship, please give me a second, Your Lordship, please. Your Lordship.
No, just correct me if I'm wrong. I mean, that's what I understood from your argument.
Your Lordship, what my argument is based on, that both claims should go to the arbitral tribunal.
I agree. I know. That's exactly what I'm also trying to understand. Yes. You could go to the next argument.
Thank you, Your Lordship. To my final issue, where the Arbitration Act provision cannot exclude an action in rem from its purview as non-arbitrable. Your Lordship, once the court orders the arrest of a ship, it retains the jurisdiction to adjudicate the substantive claim unless the order of arrest itself is vacated upon the court, being satisfied in an application made on behalf of the owner of the ship that the arrest is not maintainable. Your Lordship, a very important case is the case of the JS Ocean Liner versus the MB Golden Progress 2007, which was of the opinion that, taking into the consideration the specific provisions in the convention, the parties can be accorded the right of an action in rem under the admiralty jurisdiction of a maritime claim, even if an arbitration agreement with a foreign arbitration seat exists. My My petitioner, the petitioner mentioned earlier that the general average contribution cannot be mentioned under the maritime claim. For this knowledge and for the sake of this honorable court, I would like to make emphasis and clarification on the definition of the maritime claim and the counterclaim, supporting them with provisions. Your Lordship, a maritime claim is what is within an admiralty jurisdiction to grant what includes a maritime claim. A counterclaim is the claim filed by the respondent in the arbitration proceeding. According to the International Convention relating to the arrest of seagoing ships of 1952, the Part G mentioned that a type of maritime claim is the general average claim. And also, according to the Section 4 of the Admiralty Act, paragraph Q, it leads to the general average claim as a maritime claim. Your Lordship, it is important to know that for the sake of this honorable court, an action in rem is a proprietary action brought against the object that is the subject of a dispute. Your Lordship, the determined rights adjudicated as a result of an action in rem are conclusive against the whole world rather than merely between two parties to a dispute. Your Lordship, action in rem are prevalent in the sphere of an admiralty law. An arrest of a ship is an action in rem, as if the vessel has a juridical personality. The position taken by the court is that a suit for the arrest of a ship to secure a maritime claim would not be affected merely because an arbitration agreement with a foreign seat exists. This is also stipulated expressly in the conventions. Your Lordship, the principle in the case of Vidyadrolia versus Doga Trading Corporation of 2021, which relates to an action in rem that does indeed give right to the subordinate right in personam that arise from a right in rem. The subordinate right in rem being the claim for the general average in this instant case. Your Lordship, in the issue, in fact, is whether or not both parties fulfill their contractual obligation. It is not as to the arrest of the ship. The impact of the arrest of the ship is because of the location of the court. Your Lordship, bringing this instant case, if the arrest was in London, this issue would be in London. This issue will be in the London court, so that the only effect the arrest of the ship has in this issue is the location of the court. Your Lordship, the court even held in the case of Anyam Sami versus Paramasivan, which is a case mentioned by the petitioner. The Supreme Court had ruled that mere allegations of fraud which touch upon the internal affairs of the party and has no implication in the public domain cannot house the jurisdiction of an arbitral tribunal. Your Lordship, conclusively, contrary to the claim of the petitioner, the principle in the case of Vidyadrolia regarding when the cause of an action and the subject matter of the dispute affects third party does not apply in this case, because the insurance company which seeks to collect the debt is a company which is listed under the SDN. Your Lordship, the petitioner mentioned that the SDN is only restricted to the United States. I seek your indulgence to correct that opinion, because the United States is under India is under the United Nations, the part of the United Nations, and the United Nations made a rule about the SDN. The SDN list, it consists of individuals, the groups, and entities such as terrorists and narcotics traffickers disseminated under programs that are not country specific. The petitioner mentioned that if you are having a business with Amazon and they are having and they are being listed as a part of the SDN, can we say India should stop having a business with them? The answer is no. It is important to know that is my learned counsel in an argument, is she trying to tell me that the India should be dealing with terrorists or narcotic traffickers? No, my lord. Article 2 of the International Convention for the Suppression of Financial Terrorism provides that anybody who performs an offense, it requires the state to take action against anyone who performs financial support to terrorists exemplified by those on the SDN list. I take that last article again. Article 2 of the International Convention for the Suppression for Financial Terrorism. it provides that anybody who performs an offense which requires the state to take action against anyone who is financing the support to terrorists exemplified by those on the SDN list. Conclusively, Your Lord, Your Lordship, I can't hear you.
Counsel, one moment. You are actually dealing on which of the issue? The fifth issue, right? Does the provision of the Arbitration Act exclude an
Yes, Your
action in
Lordship.
rem?
Yes, Your
I
Lordship.
believe you tend to argue more on issue number 3 than issue number 5. So are you actually speaking more on sanctions, or
No,
the issue is quite simple. The issue is whether the Arbitration Act excludes an action in rem from its preview as
Yes, Your Lordship.
non-arbitrable. How do you? I mean, I don't find the relevance of your argument in this issue. So
thank you for this question, Your Lordship. Well, I feel like in the foregoing of my argument, you will be able to see my argument on the issue number 5 more. I just had to buttress the issue number 4 and issue number 3 in addition to this, Your Lordship. Permit me to proceed, Your Lordship.
Yes.
Thank you, Your Lordship. Your Lordship, it is important to know that an arrest of a ship is an action in rem, as if the vessel has a juridical personality. The position taken by courts is that a suit for arrest of a ship is to secure a maritime claim would not be affected merely because an arbitration agreement with a foreign seat exists, as the convention contained express provision in this regard. Your Lordship, furthermore, Section 17 of the Arbitration Act, it empowers an arbitration tribunal with the same powers as this court. Hence, they have the power to sit on cases dealing with an action in rem, just like the court would under Admiralty law.
But the arbitrational tribunal doesn't have the power to arrest the vessel, if you actually know.
The arbitration tribunal does not have the power to arrest the vessel.
Yes.
Your Lordship, this court has the power to listen to the arbitration tribunal. To listen to the arbitration process before taking it to the actual procedure. Come again, Your Lordship.
No, so basically, what are you trying to put forward? Like, as an interim measure, we can arrest it and then it has to be decided in arbitration. Is that what you are trying to raise in your argument?
What I'm trying to raise in my argument is that the Vidiadrolia case, which talks about the cause of an action and the subject matter of the dispute, it affects the third party. It does not apply in this case. And this court empowers an arbitration tribunal with the same power which this court has. So this court has the power to sit on cases dealing with an action in rem, just like the other courts, but not basically the arrest of ships right now, Your Lordship.
Come again, the last argument. What do you say last?
Your Lordship, I said according to Section 17 of the Arbitration Act, which empowers an arbitration tribunal with the same power as this court has the power to sit on cases dealing with an action in rem. This court can also arrest ship through an order.
We have no doubts on that. But how do you substantiate your claim? Does the provision of the Arbitration Act exclude an action in rem?
Yes, but the action can proceed to an arbitration tribunal, Your Lordship.
Come again?
The arrest of a ship, Your Lordship. As I mentioned earlier, the arrest of a ship, Your Lordship, as I mentioned earlier.
No, I'm trying to focus on the issue that you are raising. The issue that you are addressing is, does the provision of Arbitration Act excludes an action in rem from its provision as non-arbitrable?
Yes, Your Lordship.
I'm trying to accept.
Okay, Your Lordship. What I'm trying to say is that they have the power to sit on cases dealing with an action in rem, just like the court would under the Admiralty law. In the case of the Anya Sami versus the Paramasivan and others, the Supreme Court had ruled that the mere allegations of fraud which touch upon the internal affairs of the party has no implication in the public domain. It cannot house the jurisdiction of an arbitral tribunal.
Okay.
Your Lordship.
Your argument is that the arbitral tribunal has the same power as this honorable court, so they can sit on the same right and not this court. If I'm right?
Yes, Your yes. This issue is against the two parties and not against the world, Your Lordship.
Okay.
Thank you, Your Lordship. Conclusively, the respondent submits that the Arbitration Act does not exclude an action in rem from its purview as non-arbitrable. Your Lordship, I counsel seeks the leave of the court to proceed the prayers.
One moment. Does my co-judge have any other questions to the speaker number two?
Definitely, but something related to the facts that is stated in the case. Why was there a delay in allowing the claimants to board the vessel for inspection?
Sorry, please. Your Lordship.
Why was there a delay in allowing the claimants to board the vessel for inspection?
Your Lordship, the delay can be regarded as a result of the political unrest at the time the delay happened, at the time the issue happened, Your Lordship.
Fine. May proceed with the prayer.
Thank you, Your Lordship. Most grateful, Your Lordship. Your Lordship, conclusively, in the light of the facts stated, the issues raised, the authority cited, and the argument advanced, it is most humbly prayed and implored before this honorable court that it may be graciously pleased to declare that the court owed that it has no jurisdiction to hear the case and declare the arbitration agreement valid. That the court refer the parties back to arbitration since a valid arbitration agreement exists. That the court produce a mandate. That the court mandates the claimants to pay for any loss or damage which may have incurred by the defendant as a result of his arrest. And lastly, that the court owed that an action in rem is arbitrable under the Arbitration Act. Conclusively, for all the reasons put forward today, the petitioner, the respondent requests that this honorable court uphold the prayers of the respondent. Subject to any further questions, these are my submissions. Most grateful, Your Lordship.
Yes, rebuttals.
If the lordships are ready, then the team IMC 113 may start with your rebuttal. Your rebuttal time is 2 minutes.
Your Lordships, the respondents have asserted that this honorable court lacks the jurisdiction to arrest the vessel, that is MV Moonlight, as per Section 7 of International Convention of Arrest of Ship. And as was duly pointed out by your Lordship as well. However, International Convention on the Arrest of Ships 1999 is no longer applicable in India pursuant to the enactment of Admiralty Act 2017. All the existing international maritime conventions have been consolidated into one legislation with respect to all settlements of maritime claims and the issues arising thereunder, and are indisputably presided over by Maritime Jurisdiction Act. So therefore, the council contends that the respondent's assertion is lacks substance and is invalid. Moreover, the council also mentioned, the council on the behalf of respondents also mentioned that action in rem cannot be arbitrated, which essentially substantiates the present council's submission. This is all the council on behalf of Octa Limited has to say.
Council, it's applicable to Indo, not India.
Indeed, your lordship, the council begs your pardon.
You've been using it quite a few times.
If you may allow the laws of Indo are the laws of India are paramateria to the laws
I
of Indo.
agree.
So
I agree.
if
I
that,
agree on that.
yeah,
As counsel
you're
arguing in moot courts, these are things that you should keep it in mind, to state
yes,
the correct
indeed,
things.
certainly.
Yes. Any further rebuttal from your side? Yes,
No, Your Lordship.
109.
Your Lordship,
So if the
Yes.
lordships are ready, the team IMC 109 may start with your rebuttal. You have a rebuttal of 3 minutes because the speaker 2 has exceeded the time by 2 minutes. However, if the judges feel that it is justified, they can be granted
Yes.
a total of
5
5
minutes. Let them know.
most grateful, Your Lordship. Your Lordship, the petitioner mentioned in her argument that the SDN list, people who are found in the SDN list are to be exempted from having business with the people with India. As mentioned earlier, the SDN list, for the purpose of clarification to this court, the SDN list consists of individuals, groups, and entities, such as the terrorists and the narcotic traffickers, designated under programs that are not country-specific. Collectively, such individuals and companies are specially designed nationals, or SDN. Their assets are blocked, and persons are generally prohibited from dealing with them. So such person does not qualify to be regarded as a third party. In this instant case, Your Lordship, it is important to know that India is a member of the United Nations, a founding member of the United Nations, which was created in 1945. And the United Nations is a sole standard of the SDN. They are solely against the SDN. So therefore, it is important to know that a person who is in the SDN list should not in any way be regarded as a third party in this instant case. My learned colleague also mentioned, for the sake of emphasis, that if a person is having a business with Amazon, that will India stop having a business with Amazon because Amazon is listed under the SDN? The answer is negative. Is my learned colleague in an argument trying to tell me that India should be dealing with terrorists or narcotic traffickers? No, the sole purpose is to for the safety of the people. Article 2 of the International Convention for the Suppression for Financing of Terrorism, it provides that anyone who performs the funding of terrorists with any financial support exemplified under the Act will be against the United Nations. Most grateful, Your Lordship. I would like to defer proceedings to my learned counsel.
Okay.
If our time is not up, Your Lordship, I want to quickly bring to the notice of the court that while we agree with the petitioner that the presence of the Admiralty Jurisdiction and Settlement of Maritime Claims Act, which was made in place, overrides that of the other conventions. However, this other convention are of persuasive effect before this honorable court, Your Lordship. And also, our argument before this honorable court today is not solely based on the conventions, Your Lordship. I address this court as regards the Arbitration and Conciliation Act of 1996 and other relevant acts. And we hope this court do justice to our submissions, Your Lordship.
Yes. All proceedings done. Can we talk with the participants now?
With the permission of the court, let me inform that the team is in the time for tabulation. So the teams may please leave the court. The time to talk with the participants will be after the tabulation process.
Okay.
So that they don't see the marks.
Sure.
So the team members, that is the participants, have to leave now and the team managers have to stay. Yeah, Your Lordship, I hope that the tabulation sheets are handed in, and if there is any ambiguity, you may please convey it to us.
I have. Yes.
Much obliged. Your lordships may now discuss the marks with each other and then arrive at a conclusion. Then we can later send it to the tabulation team and present it in front of the participants. Thank you, Your Lordship.
നമസ്കാരം. എന്തോ ഒന്നു പിള്ളേരാ.
Hi. Nice to meet you. എനിക്ക് except for the discuss ചെയ്യാലോ അല്ലേ?
ചെയ്യാമെന്നാണ് അവര് പറഞ്ഞത്.
Yes, ma'am. Yes, ma'am.
IMC 113 I think speaker 2 was good.
Yeah. Speaker 2 she was the best out of the
Best of and rest എന്താ പറയാ
സ്പീക്കർ 1 ഇവര് ഇടയ്ക്ക് മാറിപ്പോയി. ഈ 109 പല ആർഗ്യുമെന്റ്സിലും
മാറിപ്പോയി. അത് എനിക്ക് ഒരു ആവറേജ് പെർഫോമൻസ് ആയിട്ട് തോന്നിയുള്ളൂ രണ്ടുപേരും. And 113 speaker 2 and speaker 1 was not that good, but then
speaker 1 was okay. I think speaker 2 of 109 113 and speaker 1 of 109 was also good. He was
trying to explain things.
Yeah. Knowledge of it. Knowledge and understanding of facts. 20 അല്ലേ? I'll give ഞാൻ കുറച്ച് മാർക്ക് വാരി വിതറുന്ന ആളാണ് കേട്ടോ.